Hey everybody, this is Matt Larson. Hey, in this video I am going to go over your real estate purchase agreement. So when you put a house under contract, this is the agreement you're going to use. So let's just get through it. This is the agreement I use. It's a shorter version. You know, every state has their own state certified version of their purchase agreement, and realtors use that. This is what I found is those really long purchase agreements, they're great. I mean, they have everything under the sun in them that you could ever dream of. The problem is they intimidate a lot of sellers. So I like to use this shortened version. It still has all the protections in there that I like. And it's very quick and easy to fill out, and it eliminates some of that seller, people that are afraid. So anyway, let's go through it. First of all, this agreement is made on, you'll put that day's date, the seller, which is whoever owns the property. The buyer is you, and notice that there's and or assignees after it. That gives you the ability to assign the contract. Seller agrees to sell and buyer agrees to buy the following: describe real property together with all improvements and fixtures and the personal property described below. So you'll put the street address in there. You don't need to fill out the legal description. The title company will do that for you. If there's any personal property that goes with it, you can add that in. For example, a lot of times people include the appliances. You'll put the purchase price, the earnest money deposit. Now, I always use, when I'm buying a house, I try to get as little amount of earnest money as possible. Many deals I do is $1. A lot of people have a hard time believing that, but honestly, I put $1 in there. It's already pre-filled out. We don't even get into it. And in the odd chance that a seller says, hey, I noticed that you only have $1 earnest money in there and I want $3,000. Well, I always tell the seller that, listen, it's not like you're going to get $3,000 earnest money and you can go to the mall and go shopping. That money goes into escrow. And you'll notice that it says will send to escrow upon agreement right after that. That money's going to escrow. They don't get it till closing anyway. And I just tell them that I do a lot of deals and I don't like tying up a lot of money into earnest money. So you'll take the purchase price minus the earnest money, and that will be the total due at close. So, for example, if you bought the house for $50,000 and you put down $1 earnest money, you would owe $49,999 at closing. Earnest money is refundable due to any of the following conditions and as set forth in subsequent sections of this agreement. The buyer finds the condition of the property unsatisfactory at buyer's complete discretion. So, what that does is you can decide you don't want the house for any reason and you're out of it and you get your money back. If you have $1, there's not a lot to risk anyway. B, if seller fails for any reason to perform under any of the term contained herein. And then buyer, at buyer's complete discretion, deems the transaction to be commercially impractical. So what that means is if you get all the way through it and the numbers just don't work, you back out, you get your money back. You can tell I had my attorney build this contract to protect me on all my purchases. So prorations in pounds and securities. What I'm getting at there too is don't be afraid to put something under contract. This contract will protect you. Now, I'm not an attorney. Seek your own attorney's legal advice. That's my disclaimer. Get your own contract. But this is what I use, so I've done really well with it. So 2A, real estate taxes based on the most recent tax information available, rents, if any, interest on assumed debt, if any, insurance premiums, if policy assigned to buyer, any other income and operation expense. Again, that's something that your closing, your title company or real estate attorney will help you with on any of that. The special assessments, again, if there's any liens on the property, the seller will have to clear those up. You will initial at the bottom, the seller will initial at the bottom. Expenses of transfer, basically this says, hey, everybody's paying their own expenses. You pay your own closing costs, I pay my own closing cost. You pay your attorney's fees, I pay mine. Fixtures and personal property, you want everything attached to the house. You don't care if there's appliances in there or not. It doesn't really make any difference, but this just protects you from all that. Then you got your inspections on number 6. This is important. So you want to put in, the buyer may conduct any inspections reasonable necessary to accurately determine the condition of the property. If any of the inspections are unsatisfactory, at the buyer's discretion, this agreement may be terminated and the earnest money returned to the buyer. So, important. So again, you can tell I created this to give me protections. I can say, hey, an outlet doesn't work, I'm out of the deal. And this contract would allow you to do that. Obviously, you're not going to use something so simple, but if you decided to, you could. Buyer has an inspection period of blank days. Now, if this purchase agreement is 30 days, you want as much inspection as possible. So if you want, put 30 days. I a lot of times put 14, but put as many as you can get. And then you get blank days to let the seller know after the inspection period ends if there's anything that came up that you just don't want to buy the property. So a lot of times I'll put, hey, 15 days inspection and I have to let you know within 15 days. That takes me all the way through closing. A lot of times people will put 5 days after the inspection. To condition of the property, you either circle as is or as is except condition. If the seller warrants the plumbing, septic, and sewer, water line, heating, all of the mechanicals, but you're buying it as is. You're getting it at a really good discount, you're buying it as is. You're not asking for any warranty. That's one of the reasons why you're getting it at a good price. And then number 8, you're gonna put in the closing date of this transaction. So if it's 30 days and let's say today is January 1st, then you're gonna close on January 30th. And the next line, closing will be held at, that is your title company. Very, very important that you put your title company. If you decide to double close this deal, you always have to double close. This is very, very important. Write this down, highlight it, mark it, whatever it is, but you always have to do a closing at your title company. This allows you to double close. If you don't close at your title company and you have to close somewhere else, the double close will be impossible. So, seller agrees to transfer marketable title free and clear. You will always, always, always want to get a free and clear title. You do not take a quick claim deed, you take a warranty deed. Then you initial at the bottom. Again, this just talks about the abstracts or the title. Very simple stuff. If it seems complicated, again, there's nothing to sign in those spots. This is all legal jargon. Get with your title company attorney if you need help with any of that stuff. Escrow. This agreement will be closed through an escrow with the buyer's attorney. Again, we're focusing on where we want to close. So number 10, damage of property. The property's got to be in the same condition it was when you're put it under contract. Number 11, if the buyer defaults under this contract, this is an important paragraph. If the buyer defaults under this contract, all monies deposited by buyer shall be retained by seller as full liquidated damages, and said liquidated damages shall be sole remedy. What that means is, if for some reason you go way past the closing date and you decide to bail, you couldn't wholesale the deal. Now remember, as long as you stay within the inspection period and within the dates of the contract, you're out free and clear. You could say that you don't like the color of the walls and you're out. So you don't really have any reason to not back out on time. If you just get lazy or careless and you don't back out on time, then it goes to this default. But the default is just the earnest money. So if you only put up $1 and you backed out way too late and you went past all the contracts, the only thing they can go after is your dollar earnest money. See how it's no matter what, don't be afraid. This protects you in every way, shape, or form. So that whole paragraph kind of keeps you safe, but it does say if the seller defaults, buyer may pursue all remedies allowed by law. So again, this is totally set up by you, for you. So if the seller says, hey, I found somebody that would sell this, that would buy this house for me for $5,000 more, you can go after them. You will get that house for nothing. So they have no chance. Okay, so investor purchase, seller acknowledges that the buyer is a real estate investor and that this property and this transaction may be incorporated into one or more series of multiple transactions that require simultaneous close or near simultaneous closings. As such, seller hereby acknowledges that the closing date set forth in paragraph 5 herein is above an estimated closing date and that the closing may take place before or after said date listed. Now, again, another protection. So what this says is that you're an investor. You might double close it. You might simultaneously close. So another word for double close is simultaneous close. That's what you're referring to. You're just being transparent. Nothing they can say or do about it. They agreed to it. So another protection. Again, initial it, last page, financing. If applicable, this agreement is contingent upon buyer financing, obtaining financing acceptable to the buyer. The buyer agrees diligently to pursue the acquisition of financing prior to closing. In the event the buyer cannot obtain financing acceptable buyer, this agreement shall be terminated and earnest money returned to the buyer. Again, setting you up for safety. So if you decide to finance, then you can with this agreement. Obviously you're not, you're gonna use cash. But if you decided to finance and you got turned down for financing, the deal is terminated and you even get your earnest money back. So, legal assistant, the seller and buyers are aware that when fully signed, this is a legally binding agreement for the sale and purchase of real estate, and that in order to protect their interest in connection with contractual, title, and other aspects of this transaction, they have the right to consult legal counsel before the agreement is signed. So if they want legal assistance, they can get it. You sign it and date it, they sign it and date it, and you're done. So I think you'll see that this purchase agreement is very easy to read, very easy to fill out, and it protects you big time. So I hope that helps. Use this agreement, and we'll see you in the next video.